number 112492, State of Kansas v. Boren Earl Fitzgerald.
May it please the court, Ian Audie, Deputy Cali County Attorney for the state. I would request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This case comes on from a conviction for aggravated criminal sodomy. The defendant was originally charged with causing a child under the age of 14 to engage in sodomy with another, and then was convicted at trial for aggravated criminal sodomy. The jury was instructed to convict him if they found that he caused a child under the age of 14 to engage in oral contact with his male genitalia. The defendant appealed, alleging that and then at appeal.
I'm sorry, could you back up for a second? Did you just say that the instruction matched the charge?
That is my argument.
I thought the instruction did not match the charge.
That is the point of contention on this appeal.
Well, it either does or it doesn't.
Well, the charge was that he caused a child to engage in oral contact with I don't have it right in front of me.
Another
person's
or
genitalia.
A person or
a
any person.
I believe the
Right.
word used in the complaint was another. The word used in the statute is any person.
Right.
And then the instructions instructed the jury to find that he caused the child to engage in oral contact with his genitalia, which the point of contention is whether he is another person or not, as charged in the complaint.
Is that your argument, that the crime instructed on is the same as what he was charged with?
That is one of my arguments, yes. So I have a series of them. But yes,
is that your position here? Because our case law says another person is not the defendant.
Correct. Dickinson stated that any person does not include the defendant. My argument is that the plain reading of the statute is that the defendant is a person, and therefore he is clearly any person, and therefore he is within the subsection as charged in the complaint.
Counsel, the instruction, I think I'm reading from the language, says to establish this charge, each of the following claims must be proved. And number one is that the defendant engaged in sodomy with the victim, which is a different subsection of statute, right?
Correct.
Right. And then the second point is that he had the victim engage in oral contact with his genitalia. So is it your position today, and isn't this the first time that you're taking that position, that it basically instructed on both subsections of the statute?
That is my position, and I'm sorry, I thought that was included within my brief. If it was not, then I apologize. But yes, it instructed the jury to conclude that he violated both sections of the statute, with the acknowledgement that under Dickinson he would not be any person. But my argument is the plain reading of the statute is that he is clearly a person, and therefore any person encompasses him.
Then why have two subsections? That would essentially render the first subsection superfluous and meaningless, and we don't construe statutes in that regard, do we?
I believe that it was the intent of the legislature to make sure and cover all situations, so there may be some overlap between the two. But if the court does believe that there's a strict separation is necessary, then I would offer an alternative explanation that the person engaging in the sodomy is the one in oral sodomy is the one performing the oral sex. And so if the defendant performed oral sex on the victim, then he would be engaging in oral sodomy with her. And if he causes her to perform oral sex on him, then he is causing her to engage in oral sodomy with any person.
Then how is your evidence sufficient on engaging? Because all of the evidence was that he had her perform oral sex on him. So how can you say the evidence is sufficient under number one that you say needed to be proved, the engaging? Doesn't that put you on the horns of the dilemma?
Yes, Your Honor.
Okay. Let me ask another question, kind of more global. Let's assume, for the moment, just for purposes of argument, that we think that the instruction is consistent with the evidence but inconsistent with the charge. What controls our analysis of a sufficiency argument, such as the one brought by the defendant on appeal? The charge or the instruction?
I would argue in this case the instruction, because the defendant was put on notice what he was supposed to have done all throughout the.
But that doesn't answer the legal question. I understand that's what happened factually. He certainly had notice. Nobody can really dispute that he didn't know what he was being tried on. That was all the evidence, and there wasn't any objection to the instruction, and we all know that. But should the instruction control? Why does the state get to pick at that stage without some sort of amendment of the charging instrument?
Your Honor, I believe that because, frankly, I think that ideally everything would have matched all throughout.
Sure. That would help everybody.
We wouldn't be here. But I think that when everyone is on the same page about what he's supposed to have done, holding the state to the strict language of the complaint allows, when the defendant didn't object, he at no point objected until appeal. He didn't even object after the verdict. Well, he didn't object on the grounds that it was the wrong subsection. He didn't object on what we're talking about here. So
that's apparently true, but there was no preservation argument raised before the Court of Appeals by the state. Correct?
correct.
So you have a preservation problem with preservation.
I understand that.
So skipping over that for the moment.
I think it goes even farther back, and the defendant didn't preserve the issue in the first place. And so it would allow a defendant to notice a problem like this or a purported problem like this and not say anything about it. And then once he's convicted, say, oh, wait, there's a problem, and get a new trial.
And whose obligation is it to charge and prosecute? It's the state's.
It's the
isn't it?
state's.
And it doesn't seem to me that it's all that onerous to expect the state to charge the crime it intends to prove.
And, Your Honor, that's why I go back to the plain reading of the statute.
Well, I understand that argument, but we're arguing now, we're talking now about assuming we disagree and that they are two separate subsections and that our prior law is still good law with another person or any person doesn't include the defendant. What you're essentially doing, or what happened here, was amending the charging instrument with the elements instruction. Isn't that actually what happened?
I suppose you could view it that way, yes.
Well, I mean, really, you're asking the jury
Constructive
to decide whether these charges have been proved, and it's not the charges in the charging instrument, it's the charges on the evidence that you put in the instruction. And
Correct.
so that's a de facto amendment of the charging instrument, but 223201E says you're permitted to have a charging document to be amended at any time before verdict or filing if no additional or different crime is charged. So basically, you're doing by an instruction what you could not have done under that statute by motion.
Yes, that is the effect of it. Yes, I would agree with that. However, I think that obviously things didn't agree. There was error here. I think to any extent there was error, it was harmless error because of the fact that the defendant was put on notice of what he was supposed to have done from the very beginning. There was a preliminary hearing. He was bound over on this charge. He didn't raise the issue between what he was charged with and what he was supposed to have done.
Counsel, would you agree with me? You can make a harmlessness argument on a complaint problem, but not on a sufficiency problem. Sufficiency gets you an outright reversal as a defendant, doesn't it?
Yes.
So we return to my original question about what should control, the charge or the instruction. And what's your best argument or best case or best law to support your position that the instruction should control when there's been no formal amendment of the charge?
I believe the instruction should control when it's clear that from the process, everyone has been on the same page about what is sought to be
So I
proved.
understand what you believe. Now, what's the law you cite to support your belief?
I do not have case law to support that position.
Okay, thank you.
When you say he was bound over on the charge that he was actually charged with, correct?
Correct. He was bound over on the charge as listed in the complaint. The reason I raised that is because he saw at the preliminary hearing what the evidence was that the state sought to prove, and it always, at all times, involved him causing the victim to engage in sodomy on him. And so, at all stages, everyone was on the same page about what the state was trying to prove.
Well, is this just a mistake of law then that infected the case from really early on as opposed to an evidentiary defect?
Yes, it is. The original charging prosecutor read the statute, thought any person applies to the defendant, and charged that subsection.
And apparently the courts bought that
Right,
interpretation of the statute since the courts bound him over on these facts.
Correct. The defendant never raised an objection to that. The court, I doubt the court even looked at it as a potentially wrong charge.
If it's a mistake of law as opposed to an evidentiary deficiency, does that impact the remedies that are available on appeal?
If it's a mistake of law, I believe the court can uphold the district court if it's right for the wrong reasons. It also goes to harmlessness, and I'm sorry I didn't look at it from that perspective initially, so I don't have.
Does it go to whether the defendant's entitled to an outright reversal versus a remand for a new trial?
Yes, because if there's insufficient evidence, then the defendant, that's an acquittal, and double jeopardy applies. But if the court finds that it was error and that it was not harmless, but that it was a legal error, then the court can simply reverse it, send it back for a new trial, and then there's at least the possibility that he would get another trial with the correct charge, and have everything right from the get-go as it should have been this time.
And are we left with your say-so that this was charged incorrectly rather than the evidence came in differently than expected? Because if you charge a crime, if you had charged it as the statute plain reading says of causing the victim to engage in sodomy with someone else, but the evidence didn't come into trial that way, it came in and indicated that it was sodomy with a defendant, and jeopardy is attached because evidence has been presented, is it okay then to amend or to send it back for a retrial, or can you fix that at that point?
No, Your Honor, because then that would impact the defendant's constitutional due process rights. He was not put on notice of what he was charged with.
So how do we know that your office made a mistake of law?
There was a preliminary hearing where evidence was presented. The defendant was aware at that point of what he was intended to be charged with. The defendant received discovery. He received all the police reports, the defendant has never alleged that he did not know what the state was trying to prove. Every party knew at all stages what the state was trying to prove, and there was just an error as to which subsection applied to those facts.
Did I understand you correctly that the charging attorney or the person responsible actually thought that with another meant was inclusive of the accused? The perpetrator of the sodomy?
Yes, that's not in the record. That's from speaking with him. So I can't, but I know personally that, but obviously it's not in the record, and I understand the court can't necessarily base its decision on that. All right. I'm out of time unless there's any other questions from the court.
Any more questions? Thank you, counsel.
I'm Michelle Davis. I'm here on behalf of Mr. Fitzgerald. I think my comments will be brief. In terms of the meaning of the statute, this court in Dixon, with Justice Allegrucci, went through the legislative history in detail and explained that by different subsections what was going on with the legislature there. So I think that opinion speaks volumes to that question. So I'm going to skip over that part. And then in terms of this is structural error, his right to notice in terms of the charging document, and also there's the Fifth Amendment right to an indictment, and we don't have that in Kansas. We substitute the preliminary hearing. So if the state's going to amend the complaint, then a defendant's entitled to a new preliminary hearing. And so with any sort of constructive amendment of the complaint, the defendant isn't afforded that opportunity. So basically, this is structural error here. And then there is insufficient evidence.
Do you have any cases that show that structural error?
Refer you to U.S. versus Farr, 536 F. 3rd 1174, the 10th Circuit, 2008. And I'd also refer you to that case for the proposition that if there's insufficient evidence, it has to be an outright acquittal. In that case, they did find some sufficient evidence on the original indictment, and so they did refer it for a new trial, but it supports that proposition that if there isn't.
My understanding of the federal case law is that generally they consider the instruction to be a constructive amendment. Does that 10th Circuit case stand for something different than that?
What I thought you were asking about was it a structural error that
Right.
they can't do that, they can't construct.
Yeah.
In that case, that's exactly.
As I said, I understand that most federal cases say that you can, through a constructive amendment at time of instructions, which would mean that it would not be structural error.
Well, no, there is a prohibition on constructive amendments in federal court. It is constitutionally prohibited. You might be talking about a variance from
The variance. And
variance versus a constructive amendment that charges, that is a constitutional violation for the reasons that I've talked about. And so far as a good case on that, you can do a variance. That can be allowed, but it talks about how you can't do a constructive amendment because of the Fifth Amendment and Sixth Amendment guarantees to notice and to trial upon the indictment.
I'm sorry, what was the name of the case again?
Yeah, it's FAR.
Could you spell that for me? I can't understand.
FARR 536 F 3rd 1174. It's a Neil Gorsuch
And
opinion
all of those
from 2008.
are all of the points that you've made within the last minute or two come out of that case.
Right, and let me see if I can get you
That's okay.
something
I've got the
else.
site. I just needed the name. Thank you.
Okay. So that would be it. If this isn't a variance, this is a constitutionally impermissible constructive amendment because effectively it's a different subsection of the statute, and that's not permissible, and that there isn't a retrial because of the insufficiency of the original indictment complaint.
Is a constructive amendment statutorily permitted in your
No.
view?
No, it isn't.
Well, why would we get to the Constitution if we have a statutory prohibition?
Well, you can go either basis.
You don't care how you win, right? Yeah.
Do you have any further presentation?
No,
Any more questions? Thank you, counsel.
thank you.
You're observed 3 minutes rebuttal.
Thank you. Essentially, my argument is that this case is, while not identical to Dunn, is very analogous to Dunn. The court is obviously familiar with its own cases with Dunn, but in that case there was an element missing from the forgery. The defendant was adequately put on notice.
The difference I see here is that Dunn says you have to allege sufficient facts. The elements don't matter, but you have to allege the facts. And how are you alleging the facts in your complaint that it was defendant that was engaged in sodomy with the victim?
Your Honor, what that goes back to the plain reading, and I understand if you don't agree with that, then that argument doesn't fly. However, I would go even more fundamentally, and Dunn, I think, stands for the proposition that if the defendant has been put on notice of what he's alleged to, what the state is seeking to prove that he's done, then his right is satisfied. He was put on notice. He's never alleged he was not put on notice. He had a trial. He put on a defense that he did not do the thing he is alleged to have done. The jury did not believe him, and it convicted him. And I think to overturn that conviction when he has had all the procedural safeguards to which he's entitled is an overreaction to what is essentially a clerical error. Given that the defendant was put on notice of what he is supposed to have done.
No, it's not a clerical error. You said that this was the charging attorney understood in his or her mind that this was the appropriate charge given the facts of the case. How is that a clerical error?
I apologize. That was an ill-chosen phrase. It was a mistake. It was essentially a mistake in research. The prosecutor didn't see Dickinson, which would have informed him that that was not the charge and that he should have charged it under the other subsection. But it was a mistake in drafting the complaint made by the prosecutor.
If the jury had, given the facts of the case, been instructed on the crime that was charged and another was defined for the jury as someone other than the defendant, there wouldn't be sufficient evidence, would there?
Correct. No, there would not.
There would not be.
All the evidence was that it was the defendant.
Any further presentation?
No, Your Honor.
Do we have any more questions? Thank you, counsel. I thank both counsel for your arguments this afternoon. Court will take this matter under advisement. That